Perfect. Um, Again, a very good morning, everyone. Couple of announcements, not just like one or two announcements to make. Tomorrow is a holiday again, so there are no classes tomorrow. And other than that, I was going through my LinkedIn and I saw a post in which, they were telling that many of the international law firms, they are hiring virtual interns right now. So if you think you can manage your coursework, your classes, and you can also do internship, that will be perfect right now. So if you are ready to do that, you can, check White and Case website. They are offering opportunities right now for virtual internships. They are not like 1 month long. I think they are like week or 2 week long. So it's not that much. Plus you get a certificate from international law firm. So, you can consider doing something on your CV. Basically shining up your CV is it's very important because you're in your final year. You'll be sitting for placements, and then also some people will be going for masters, so it will look good on your CV. So just look it up. You will find the opportunity. Okay. Let me just put up the screen first. So this is a simplified version of Incoterms until like 2015. I found. So I remember I told you every decade there are some altercations and there are some amendments to the Incoterms. So the current set of Incoterms are 2010. So on the basis of that, uh, these are these are the Incoterms derived by the ICC website. Okay, so International Chambers of Commerce website, and if you also go on the website and you click this link, you all can see the screen, right? You all can see the file, right?
Yes, sir.
Great. Okay. So if you go on this link, you can also see some example contracts and clauses available from the ICC portal. So for anyone who is considering a career in international law, basically international contracts and business law, for example, they definitely they want to go through the International Chambers of Commerce website because there are tons of resources on that website. You don't only find resources related to the drafting of the contract, but you also find typically many of the other things. You find opportunities available. ICC also offers internships to you can also check that. Also, other than that, they have basically events going on every now and then, so you can join those events now. So every event is virtual right now. They also conduct physical events all over the world. So just check the space, and it's a very interesting website. You can find ton of information over there. They have, dramatically, uh, diagrammatically, they have described all the terms with the diagrams. So, for example, EXW, which is ex worker, they'll give definition, and they also have given example. So, this is basically a very good document. I'll be uploading it. So, for definition purposes, for example, if I ask you, short questions, may if I ask you some of the terms and to define them. So, I think this you can refer to this document, and you can explain it very well. Uh, so, just by going through one of them, for example, carriage paid to, which is the CPT as an abbreviation. So what is happening? Seller pays to the transport the goods to the specified destination, and from there, the responsibility for the goods transfers to the buyer. and when the seller passes them to the first courier. So this is basically it shows the way it is done. So yeah, going to the contract, you can see the contract.
Yes, sir.
Great.
Yes, sir.
So basically what happens. Remember I told you the general clauses to the contract, and how does it start from preamble. So sometimes they start with these are the basically this is the general application. So general conditions to the contract. So basically there are more formal versions. So if you look, there are different versions for the different type of contract, but this is just like a sample version, describing the entailment of the contract. So they start with, for example, the definition part, where they describe all the definitions. For example, IFB, which means the invitation for bids. GCC means the general condition of contract. So every small term, whether it be like a very simplified version or not, it doesn't matter. You definitely have to define it. So basically, you definitely need to abbreviate it, and you need to put it in the terms of the contract. So basically, in the definition section. So yeah, and then you also they define the contract. What is the contract? Then they define the pricing. So you basically, if you go through these terms, they are self-explanatory. There's nothing significant I can see here, which will need a further explanation. Coming to the app, which is the 2.1, the application part. What that application part means, the pride, the working of the provisions. So basically, what will be the general conditions of the contract? So how, like, what is the extent of its applicability? So there they state that it will apply to the extent and not superseded by the provision in the other parties of the in the other parts of the contract. So basically, they will decide the ambit, the scope of the contract, to which it will apply. Um, Coming to the country of origin, it will say give lay down all the conditions. For example, all the goods and services supplied under the contract shall have their own origin in India or in the countries which the government of India has the trade relations. So, basically, they will define the perspective, they will define the origin point. Basically, what is the use of the what is the use of the trade. For example, if it's for commercial sector or corporate sector, what kind of products are they talking about. So basically, just in a gist, it will be defined the origin of the goods and services. Basically, they will define the nationality of the supplier. So basically, they will define the goods and services in the country of origin. Coming to the standard is basically, defines the specifications entailed to, like, for example, technical specifications. So, what does the language say? If we read, the goods are supplied under these contracts shall conform to the standards mentioned in the technical specification. So, for example, every in the annexures you can find, basically the reports entailing the specification of the product. So basically that includes, that's like an tested report. It will include the type of the product it is, and basically what are the specifications again. And remember when I told about the criteria of the specifications, they also describe the dimensions, they will describe the type, they will describe if it's sharp or not, what kind of basic uh, 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 instincts the product is carrying. So basically everything that will be defined in the standard uh, clause of the contract. So that the goods, they meet the technical specifications, and it is applicable to the goods in the country of origin. So basically this is just a sample line, type of a language they use. Now, what are the use of the contract document? So basically, this is the term we did not discuss it before. Basically, Sometimes they again on the needful basis what kind of contract it is, basically it doesn't require the further explanation um to the language scope. So basically this point will define the informational part. So for example, um, what the parties can do with the particular contract. Basically, it will define that, just for example, in the 5.1, you can see that the seller shall not, without the purchaser's prior written consent, disclose the contract or any provision thereof or any specification, plan, drawing, pattern, sample, or information furnished by either on the behalf of the purchaser in connection herewith to any person other than the person employed by the supplier in the performance of the contract. Now, including the language of the, like here, the performance of the contract is very, very, very essential. Because can anyone tell me what is the performance of contract entail to, what does it what is the perspective of including that part in here?
Sir, only during the, I think it's only during the subsistence of contract, not after the once the contract ends.
Uh, yes, correct. Uh, Also, when the reason they have included this part here is because, any this defines this is the epicenter, for example, of the contract part. Basically, it will define. So, for example, any parties, connected to the contract, so to the particular format of the contract, if they include this language here, like for example, any individual who is employed and who is connected to the performance of the contract. So it will include all the parties there. So basically they don't have to define everyone there, and they have made the disclosure very easier. So because they want to make sure that they make it very clear that these people are not other than these people, the information shall not be shared. So this is the reason of the 5.1. 5.2 is that uh, that supply without the purchaser's prior written consent make use of any document or information enumerated in the general conditions of the contract. So GCC is the general conditions of the contract. So basically, any enumeration made shall not be without the written consent of the either of the parties. Um, and yes, and also they have included it as enumerated in the GCC 5.1 subclause 5.1 except for the purpose of the performance of the contract. So what is the reason they have included this here is that everything other than the clause which has provided, other than the language which the clause has provided. So these are very typical essential conditions which are described. For 5.3 tells if what if the, something is remaining. So every document other than the contract itself mentioned in the GCC subclause 5.1 shall remain in the property of the purchaser and shall be returned in all copies to the purchaser on completion of the supplier performance. So if and for example any documents, any keyful information to the particular contract, so any keyful information which is left to the either of parties shall be returned after the full performance, so that we are maintaining the disclosure provisions of the contract. So basically, if we don't need it, why to keep it, right? Coming to the patents rights, it will define any claims of infringement, for example, so who that the supplier shall in all times indemnify the purchaser, for example, free of cost against all third-party claims of infringement of patents, trademarks, or industrial design. So whatever the product has, the IP traits, whatever the IP traits the product is carrying, that will be defined in the ambit of the patent rights, and it will be made clear that the for example the goods are good for any part of thereof in India. For example, like where does this rights, because every every time they discuss intellectual property rights, they definitely need to have some ambit of scope in it. Basically, what territory are they talking about? So, basically, if that's why they have included that rights arising from use of the goods or any part thereof in India. So, basically, if it's like, if it in again, if we are talking about the international commercial contract, this will definitely include more language than the India part to it. So, basically, it will also include, the ambit of, the uh, international market. Um, Coming to the performance security, it will give you the typical days that for example, within 21 days after the issuance of notification of the award by the purchaser, the supplier shall furnish the performance security to the purchaser for the amount. So this is something which has to be decided between the parties, pre-hand, the terms, of the performance. So the terms of the performance means, it will include that, for example, 10% of the will be given at this point. Then, for example, 40% will be given at this point. So basically, it will say that, for example, within 21 days after the issuance of the notification of the award by the purchaser, the supplier shall furnish the performance security to the purchaser for an amount of 10% of the contract value. So this is a kind of language which is included in there. And then 7.2 tells for what happens if the product is defective. So in the event of any correction of defects or replacement of defective material during the warranty period, the warranty of the corrected replaced material shall be extended to the further period of 12 months. So basically this will define the warranty provisions and what will happen if the replacement is to be done. Then amendment. So 7.3 talks about the amendment. For example, what will happen if any amendment is done to the contract, right? So, for example, in those kinds of situations, in the event of any contract amendment, the supplier shall be within 21 days of issuance of such amendment, furnish necessary amendment to the performance security. And guys, this is as we are discussing in the gist, what will happen after we discuss the unit 2. No, in unit 2 we'll be discussing UCC, which is the Uniform Commercial Code. Then we'll be discussing CISG, which is the international the UN Convention on the International Sales of Goods. And then we'll be discussing Hague Convention. So after we discuss these UNIDROIT principles, Hague Convention, UCC, and CISG, what will happen is that those, for example, if we the parties have made clear that typically in the contract they are following UCC guidelines. So now UCC guidelines have a special provisions related to the contract. They have their model laws. So basically, I have to check on what basis laws these provisions are based upon. But every sets of the title provisions, for example, the law governing provisions, they have their model clauses. So when we look upon that, we will be definitely knowing upon the different provisions. And after that, we'll again when we come to the unit 3, we'll be discussing drafting of the contract. So basically, that time we'll be sitting with assignments in the class, and we'll be drafting the contract ourselves. So basically, I'll be giving it to you the main provisions, and then you have to sit and we have to draft it together, or we'll be knowing the difference at that point of time. Any questions until this point?
So,
No, sir.
Yeah.
so sir, in every international contract, these terms that you've just discussed right now, from the definition till the performance security, would be a common thing for every contract.
It's not like basically necessary, but most of the time these are the terms which are there in a generic form of contracts. Basically you can definitely find the patents rights, the IP rights in the contract. You can find inspection and tests. So basically it depends upon the type of contract the parties are entering into. But again, definitely in different kind of it also depends upon the industry. It depends on the product. So for example, if it's like a software product, so software product will also include some technical language, for example, more technical clauses, for example, assignment and licensing, these kinds of provisions. But for example, if again it's something which is like a tradable, so the tradable size of the product, so in those kinds of situations it will include the generic form of the contract. So these are just the general provisions of the contract. But
Okay.
as we again, as I said, when we draft these specific contracts, in that time you'll be knowing the difference, and we'll be seeing different clauses which we draft in the contract. Okay,
Okay, sir.
so
Thank you.
not to worry. Any other question? Okay, so this was related to the performance. Performance also, will include a provision describing the denomination. So, for example, the performance security shall be denominated in Indian rupee. So, and what format will it be included as? For example, as a DD, and issued by the certificate from the bank guarantee. So, this is it. Inspection and test. So basically, this is the part we discussed before. Whatever the product is, it definitely has to be tested, right? Now, rights of the inspection, they depends upon the arrangement between the parties. So whether it will be on the side of the purchaser or the side of the seller. So again, but normally what happens is that inspections and tests are done by the seller itself. So the schedule of the requirement technical specification, these shall be included in this part. uh, they may be conducted at any point of the delivery. So basically, they tell you, at what time, because when the products they reach the destination, right? So definitely, the buyer has to make sure that the seller has met all the criteria. So what will happen? The buyer will send the product to the lab, and again, when he receives the product, they will be making some testings on the product, and they will be furnishing that data to the purchaser. Okay, and that time they won't be charging the purchaser because it's the uh, buyer's responsibility to do it, because the buyer is doing it for his own sake, his own purpose. Um, and why is it done again? To see that whether to conform to the required specification and the standards, that they have met those specifications and standards. So this was about the inspection and the test. Um, then coming to the packing part, packing typically, the transit, it will include the mode of the transit. For example, if it's going inland, or it's the what is the handling, what kind of handling the product will be handled upon. For example, if it's like uh, heavy handling, or basically what kind of manpower will it require. So, and the kind of packaging which is done. So basically, that provision will be included in the packaging provision of the GCC, the generic uh, part of the contract. So then the instructions will be also given. Okay, and what the instruction, for example, if you see any exporting, uh, anyone in the class who has the business of export and import here. Okay, so what generally happens, for example, if like the export houses, after they receive the order, and they they pack the product for the buyer. For example, the product they give it to the third party who is gonna manufacture the product for you. And after you receive that order, after the proper packaging has been done upon the instructions, kind of the packaging the buyer wants. For example, sometimes they want silicon packaging, for example, sometimes they'll want the puffy packaging, for example, so depending upon the key requirements of the parties, after that is done, the export house, they will make a memo. So that memo will include ton of information. For example, contract number and date. Then that memo will include the name and the address of the consignee and the supplier, then the brief description of the product, then the gross weight, packaging, the country of the origin, list of the so again there is a list reference number to the particular consignment number that will be included there, and any other government requirement. For example, again the government of India may be having some requirement that you need to have a GSTN number on the packaging. So for example, right? So that number will be also included on the packaging. So those kinds of conditions are included in the packaging instruction. Delivery of the goods. Now remember we spoke about the usage of the Incoterms, and you were like, sir, how the Incoterms will be used. So Incoterms are always, again, to repeat myself, Incoterms are used in delivery of the carriage of the goods and services, right? Now this is the part. This is why I picked this form of contract. The only one disadvantage of this contract which we are reading right now is that it is more for our domestic market. If you read the provisions, it is more centric on our domestic market. But the reason I picked it was I found in the sorry, where did it go? Yeah, I found it in the delivery provision, the usage of the Incoterms. Now if you see, um, they have mentioned in 10.2. So this is for the carriage and the goods. So Incoterms are used for the carriage of the goods and the services. So here in the 10.1, they have specifically mentioned that delivery of the goods shall be made by the supplier in accordance with the terms specified by the purchaser in the notification of the award and in the contract. So basically, it states that it is itself provided in the contract. So then again in 10.2, they will specifically mention that for example, for this purpose of the contract, FOB, CIF, and CIP shall be used to describe the obligation of the parties. Now, what are FOB, CIF, and CIP? CIP is carriage and insurance paid. So, this is will define, that the party will have the arrangement that, for example, the seller will pay, the insurance and the carriage fee from this point to this point. For example, basically from what point they are covering it. So the seller pays for the insurance as well as transport to the specified destination. So the CIP relates to the carriage and the insurance paid from one point to another point. Then the other was CI, FOB and CIF. So what is FOB? FOB is free on board. That the seller must get the goods ready for the export and load them onto the specified ship. That it is the seller's responsibility to get the products to the to the specified ship and to ship the product. So now the buyer and the seller share the cost and the risk when the goods are on the board. So when the goods are on the water, the risk will be shared by both the parties. This term is not used for the goods transported in the containers by more than one mode of transport. So basically, what happens, if the goods are halfway transferred to through air, and then they are halfway transferred to the water, so it will definitely the ambit. This typically this type of provision, it only talks about the goods which are transferred on uh, the uh, the ship mode of the transport. Okay, so basically this use of Incoterms and what kind of Incoterms have been used in the generic form of contract are to be defined in the delivery of the goods. Also, very important, it will also tell that from where those terms have been referred upon from. So, for example, if you go to the bottom of this paragraph, um, that it has mentioned that obligation of the party shall have the meanings assigned to them in the current edition of Incoterms. Whatever updated edition of the Incoterms are there, which are international commercial shipping terms published by International Chamber of Commerce, Paris, and so basically ICC has this like the head office in Paris, France. So basically, from there, they tell you that okay, fine, this is the source the incoterms are to be taken upon. Now, guys, what happens is that ICC is not the only body which comes with the incoterms. There are other domestic bodies also. For example, many industrial association. They also come with their form of incoterms. So again, typically we have to refer to the uh, one which is internationally recognized. So ICC is the one which is internationally recognized. Okay. Any questions at this point?
So,
No, sir.
Yeah. Yeah.
can shipment have multiple Incoterms?
Yeah. We can. Yeah. So for example, for this type of generic form of contract, they have taken FOB, CIF, and CIP. So now there are other combinations also, they can refer to. So they can use as many as Incoterms which can be related to the particular contract. So for example, whatever contract requires it, they can derive their Incoterms from the specified contract. Okay.
Okay, sir.
So this is again same part, transportation, FOB, free on board, Incoterm. Okay. CIF, carriage, insurance and freight, I think. CIP, which is CIP was carriage and insurance paid. So this is it for the transportation. So again, it will define the kind of transportation which is used for transferring the product. The particular arrangement made. Again, if you see, it has been clearly mentioned here that transportation of goods to the port of destination of such other specified place of destination in India, as shall be mentioned in the contract, shall be arranged and paid for by the supplier, and the cost thereof shall be included in the contract price. The everything is mentioned clearly in the contract in a very plain English language. Okay, so I think in first year you all studied a course. I think international, no, legal language. Is it correct? I think. Um,
No, sir, we didn't. It was actually for our juniors.
oh, you did not.
No,
Oh,
sir, it wasn't there.
okay. Um, so I try to take a class. It's a plain English language class. So what happens is that it will the definitive purpose of that class is just to explain everyone in our legal world, as lawyers, how language is very important, because language plays a very permanent role. So we definitely need to use plain English language into any form we are in doing. So for example, it has many exercises also. So I'll try to take one class with you where I can, define the purpose, and I'll prepare a PPT and I can give you a few examples. And because lawyers, they don't like complex language at all. So basically, we don't need to use fancy English words. We can just use simple legal English language to define the purpose of the contract. So, and it is basically just for the drafting purposes, right? Drafting, then how to email. So also how to write a memo to the parties. So for example, what is the format of writing the memos to the parties? Then it defines the IRAC format. For example, what is IRAC again? I think everyone knows it. Issue, rule, analysis, and conclusion. So the basic, for example, the basic usage which are the customary in legal world. So it defines that. So yeah, that's it with the transportation. I think everything is self-explanatory. It will also give us details on what if happens if there is any loss, any kind of damage to the products, for example. So it will say that who is going to be liable in those consequences. Then just for following the transportation part, then we come to the insurance part. Then insurance part will include the incoterms related to the CIF and CIP. So that the delivery of the goods is required by the purchaser on CIF or CIP basis. So they will tell the mode of the transportation again. That what basis the parties are supplying the products. So and they shall arrange the cargo insurance in naming of the purchaser as the beneficiary. So then they will define the value that in the case of the contract on CIF or CIP basis, the insurance shall be for an amount equal to 110%. So this is between the and it will also define the points. For example, what from what point to what point the insurance is included. So, for example, here it said warehouse to warehouse. Anything happens to the product from between that, the insurance will cover the cost. Um, then this is the documentation, the distribution of the dispatch documents. So anything related to the invoice is mentioned in here. So all the documents related to the particular export. For example, what are the documents again? The invoice, the memos, the copies of the you know bill, the hard copies of the bills, for example, and other conditions which have been predetermined between the parties. Then the packing list, which will define the contents of each package, insurance certificates, everything will be have to be dispatched, right? And it will also define the days within which it has to be dispatched. For example, within 24 hours of the shipment, the supplier shall notify the purchaser and his nominated authorities by cable or tele or fax full details of the shipment, including the contract number, description of the goods, quality, vessel. So all these conditions are to be informed to the parties within the 24 hours of the shipment. So this is related to the distribution of the dispatch document. Certificate of origin. Basically, now these are extra terms. For example, if it's going through a particular transportation, for example, if it's going through railway. Now, so the receipt of the documents which are related to the transportation will be included here. So, certificate of origin entails any documentation which is related to the point of the origin. Um, then incidental service. Now these are extra points I think which are not to be discussed in detail. Warranty is important. So warranty provision will define, the ambit of the warranty, the product will be included in. Basically, for example, here it states this warranty shall remain valid for 12 months after the goods or any portion thereof, as the case may be, have been delivered to the final destination. Then the payment terms. Payment terms are how the payment will be made. That for example, how much advance have the parties retained. Then now on shipment 90% of the contract price shall be paid. Now how they will also define the medium through which it will be paid. For example, it is paid through a letter of credit. If it is paid through letter of credit, if the commercial banks have they are using the commercial bank channel to pay, because normally in these type of transactions what happens is that they definitely use their commercial banking system to pay to the supplier. So that everything will be defined in the payment terms. Uh, Also in that they will be defining all the prices which are being included, the contract prices. For example, insurance policy which has been paid, inspection certificates which have been paid. So all these documentation which we spoke about in the earlier provisions is included here. I think that's basically it. Modification is important. That any modification made, how it will be made, uh, basically on the receipt of both the parties, on the mutual consent of both the parties, and to what extent they can be made. For example, what provisions can they draw as modifications. So this is included assignment. Basically, in some types of contract, they specifically mention that the supplier shall not assign in whole or part or its obligation to perform under the contract. Basically, that they are not to pass on the contract to any other third party, right? So then subcontracts, any kind of uh, contracts which are to be entered after the buyer and the supplier has entered into, they define if what items are permissible in those kinds of subcontracts. Delay in performance, what will happen if the delay is done, liquidity damages and termination. Force majeure, I think we discussed this before. What will happen if something uncontrollable, for example, act of God happens. So they will say that for purpose of this clause, force majeure means an event beyond the control of the supplier, not involving the supplier's faults or negligence, are not forcible. So such events may include, and it will also define the kinds of events which are included. For example, revolution, anything happens to the product through any war or revolution, fires, floods, epidemic, act of God. So that will define the performance of the contract. So termination, uh, type of termination. If the company is declared insolvent, what will happen? If there is something else in that, so it basically depends upon the convenience of the parties. What will happen in that kind of termination? Resolution, through which channel will they be resoluting? Now here they have said within the Arbitration and Conciliation Act of 1996. Now also they will describe arbitrators, condition, how many arbitrators are appointed, who shall be the presiding officer of those. So, and that decision shall be binding and final on the parties. The cost and expense related to the arbitration procedure will be paid. For example, whatever the arbitral tribunal decides. So, and it also will define the value of the contract there, and on the basically on the that, for example, where the value of contract is 15 lakhs and below, the dispute or difference arising, it shall be referred to the sole arbitrator. For example, if it's more than that, then it will be referred to two arbitrators. So this is it for that. Governing language, that English shall be the governing language of the contract. Application law, uh, basically the writing capability, the writing factor, which is that this shall be the main perspective of the essence of the contract, the requirement of the contract. Then taxes and duties. Any questions at this point? I'll upload this on the classroom also for your reference. Uh, any questions, guys?
No, sir.
Okay, great. Coming to Okay. Very quickly.
Sir, sorry to interrupt you, but then we have another class now.
Oh, you guys have another class.
Yeah.
Okay. Did we discuss? I think we did, right? Commercial contracts and government contracts. Did we do it?
No, sir.
No. Okay. So this is the topic I'll be covering then on Monday. I'll take half of the class to define commercial government contracts, and we'll discuss the culture aspect to the international contract. And I'll also upload this on the classroom, so you can refer it before the class. Everyone who won the class, please raise your hands.
Sir?
Okay. Shruti, right?
Yes. Yeah.
Okay. Great, everyone. Okay, you can put your hands down. Let me just download the attendance. Great, everyone. See you on Tuesday. Have a wonderful weekend. Happy Ganesh Chaturthi, everyone who's celebrating tomorrow. So take care and see you on Tuesday.
Thank you, sir. Wish you the same.
Thank you so
Thank
much.
you, sir.
Thank you, sir. Wish you the same.
Thank you, Parth.